friend. My people love her. I love her. My husband loves her. We all love her. You're up.
All right.
No pressure, by the way.
No pressure.
No, we're good, we're good. I like to have, more conversations than lecturing to people anyway. So I'm happy to be here. Thank you for having me. I wanted to talk about this particular topic because I do see it. I also do real estate transactions. I do closings. I'm mostly a real estate attorney. I see this issue coming up occasionally, not always, but I thought this is a good topic for realtors to have some knowledge on so that you can recognize what's going to happen early on or what could potentially happen pretty early on in the transaction. I have, traditionally, if I get a real estate contract in, I'm getting it and it's already signed and you've already had your listing agreement signed and you're already months into your relationship with whoever the seller is. If I get the real estate contract and I spy an issue there, the whole thing could potentially become derailed. And I kind of like to use real life examples because I'm dealing with one right now. I have buyers who are purchasing. They are going to close very soon, but they're closing on their second house, not the number one house that they called me about, which was almost a year ago. And it was supposed to be this very simple transaction. She called me up, said, "We want you to represent the buyer and the seller," which of course I said, "No, I cannot do that." And she said, "It's going to be really easy. I'm buying the house from my grandfather. We've already started working on it, fixing it up." And I'm thinking, oh, okay, let's see where this goes. Well, as it turns out, her grandfather had passed away and the family was under the impression that they could simply just sell the house to the granddaughter. That was not the case. He passed away without a will. And there were other descendants involved, and 3 of those descendants came forward once this whole issue was brought to court, and they contested the contract. My clients didn't want to see further deterioration of the family relationship. They didn't want the house that badly, and they walked away from it. They walked away from the improvements they put in, and they're buying another house. So again, that's kind of your worst case scenario of what's going to happen when things go wrong. And it's really pretty easy, I think, as real estate agents to pinpoint what those issues are going to be up front, because traditionally you're going to be dealing with 3 scenarios. If you have a title holder of record who has passed away, one of 3 things is going to happen. They either passed away without a will, they passed away with a will, or they passed away with an entire estate plan in place, which would include a trust. So I kind of wanted to go through those 3 scenarios to give you an idea of what's going to happen. If your title holder of record passes away without a will, they die what's what we call intestate. So their property is going to have to be distributed in accordance with the laws of intestate distribution in Illinois. And there's this big long list. It goes all the way down from what happens when there's a spouse and children to what happens when there's absolutely nobody. So it's a pretty lengthy, comprehensive law. It is going to take care of the situation, but it's going to be done in front of a judge. So the first thing that's going to happen is a probate case is going to be opened. There'll be a judge assigned. The judge has to make a determination of who are the most important parties here and who's going to be the representative of this estate, since there's no will to tell them what to do. So I think, as you can see, that process could take kind of a long time. Court dockets are backed up. There's going to need to be a lawyer involved if you don't have the time to go into court for all the different court dates. And you have to wait. You have to wait for notice to be given to anybody that's entitled to notice of this person's death. There's going to be a time lag for when those people can come forward to make a claim on the estate. So it is kind of a lengthy process. One other thing that I think is interesting that most people don't recognize: when you pass away without a will, some people say, well, the law is going to do kind of a fair distribution of my property. And I'm sure it is fair in most circumstances, but I think what a lot of people don't realize is if you are a surviving spouse and you have children, you don't get everything as the surviving spouse. You only get half, and your kids get to split the remaining half of it. So I think that a lot of people are under the impression that if there's a surviving spouse, they just kind of take over. But if you die without a will, that's just not the case, and I think that's just one more additional important point to bring up. So our next scenario is your title holder of record passes away and they have a will. So it's a little bit easier than intestate succession, but they are going to have to still go through the probate process. So the will get filed with the county. If you have just a will, your will is going to include all your information. Who you want to be in control of your estate, which is your executor, and how your property is going to be distributed. So the court is going to follow the will, provided it's been done correctly. There's not going to really be much of a dispute traditionally for what is in the will. However, it's a court case, so there are people that can come forward and make claims. So if there are creditors out there, if there's a relative who thinks they're owed money, that opens the door really for anybody to come in. It's public record, so they can come in, they can intervene in these probate cases. And again, the court is going to have to make sure that there are no such claims being made out there. They're going to have to make sure that everything's in order. For you, as those of you who are here who are real estate agents, the key thing for you is going to be, if you know that there was a will and there is an executor, that executor must have letters of office from the court in order to move forward. Once the letters of office are issued, and provided the court hasn't come up with some other kind of restriction on distributing the property, you will in fact be able to sell the property. The family might have some other issues with how to distribute the proceeds of the sale, but in terms of being able to sign a listing agreement or sign a contract for the sale of the property, whoever is holding the letters of office is the person that you need to be dealing with. And again, I bring this up for real estate agents because I think you can see that if you have the wrong person who signed your listing agreement and you find that out after you have a signed contract, the whole transaction is really in jeopardy. They could just simply walk away from you, from their relationship with you, after you've put in a lot of work because the wrong person signed the documents. Our third scenario is if the individual who passed away has the full estate plan, and that would include a trust. So the key thing to look for there as a realtor is, does the property, has it been deeded into a trust? And that's a quick look at the last recorded deed, which I hope is something that everybody is doing anyway. It's a simple process to look up, because again, that's going to be your key individual for signing any documents. If you want them to be legally binding, you need that title holder of record or their representative. So if it's in a trust and the trustee has passed away, it's going to be the successor trustee. That person will be named in the trust. And it's very easy to find if they can produce a certification of trust or they produce the trust document to you, you're going to know, okay, I'm dealing with the right person. What's nice about the trust is that if necessary, they could sign the listing agreement the day after the individual passed away. The trust is not administered by the probate court, and the property can pass without the court having any interference in or approval needed or any other documents from the court. You simply have the successor trustee sign off on the trust. So I think you can kind of see from those three different scenarios that some are easier than others. I think that the full estate plan is the easiest route for the loved ones who are left behind. So I thought I would talk a little bit about, when I say full estate plan, what I mean there. When somebody comes to me and we decide that a full estate plan is what's going to be best for them and their family, this is what I will do. So if it's a married couple, the first document is going to be a new will for both of them. We call them mirror wills because they kind of say exactly the same thing. What the will is going to say when I do these full estate plans is that everything that they own goes into their trust. And the reason I do that is because when I do a full estate plan and we've determined that a trust is the right way to go, I need to make sure that everything lands in that trust. And we will go through their assets and we'll make sure that anything that we can transfer to the trust is transferred to the trust. But the will itself is kind of used as a safety net. So if there's something that was missed, if there's something, disputed, the will makes sure that all property is transferred into the trust at the time of death, to the extent it can be transferred at that point.
Does it matter what kind of trust, like family trust, land trust? What kind of trust it should be?
Yeah, and that's a great question, because there is a lot of confusion around that. So a land trust is a trust that's created with a land trust company. So if somebody has the property in, Chicago Title is the biggest one, the one I see the most frequently. That person that I'm working with on their estate plan doesn't even own the property anymore. The land trust company owns it. So there's a second step of consideration that we go through with that to see who is the beneficiary of that land trust. Is it my client? Is it their kids or somebody else that they've named? Or is it a trust itself? So we'll take a look at that. If the person who's coming to me as my client who wants an estate plan is named as the beneficiary of a land trust, we will change that when we do the trust. So the type of trust that I'm talking about here is specifically an estate planning trust. It's not something that we want to generate income during its life. It's not a trust fund. We're not pooling money into it during somebody's lifetime to make it generate more income or use it for the benefit of another person. We're using it for the sole purpose of making sure that the individual's estate at the time of their death is worth less than $100,000. And the reason for that is $100,000 is the threshold for probate. So it's good to kind of think of it as the individual, the person is here and the trust is over here. When you create a trust, you have a separate legal entity that is entitled to do things like buy and sell property, have a bank account. It's kind of just like a person. Your estate is you the individual. So what I do with my clients is I say, okay, if you passed away tomorrow, what's going to belong to you and what's going to belong to your trust? And if we can get to the point where the trust is going to own the majority of the assets, you as the individual, even though you control the assets while they're in your trust, you as the individual are worth less than $100,000. And that makes the whole process easier. You don't have to go to probate. Another benefit of this is that even though you avoid the probate court process, everyone's will still has to be filed with the county and it becomes public record. So if you kind of like your privacy a little bit more, your distribution of your property when you create a trust is going to be in your trust. It's not going to be in your will. The will simply says, I'm giving all my property to my trust, and that's what gets filed with the county. So if you have a nosy cousin in Arkansas who wants to know if they're getting any money, they can't go, to the will and see it in the county records. It kind of gives you a level of privacy with the distribution of your property. Sure.
Yes, so all wills should be recorded with the county?
Yes, I was going to get to that at the end.
Okay, keep going then.
Yeah.
That's fine. That was oops.
No, it's required within 30 days of the individual's death. The law requires you.
Okay, that's when it's, okay, so it's not when it's done.
No,
but it is recorded.
Yes,
as what it is.
That's one of the
Very good.
the final steps you need to take.
I can pay attention now. Thank you.
So we do the wills that will say we're putting everything into this trust, and then obviously also we create a trust as part of this full estate plan. And again, the trust is going to be the document that's going to help these individuals, family members have to avoid probate. I will also do a certification of trust for my clients. That's a 2-page document that sets out some key legal terms associated with the trust. It's great to have. Real estate is the perfect example because for most people that's their biggest asset. So if they go to sell the house, the title company is going to say, okay, I see that it's in a trust, but I need to make sure that whoever's signing this deed is actually the person the trust says can sign the deed. I'm sure you can easily piece together the different levels of fraud that could go on there. So the title company is going to insist on verification. The certification of trust will do that for them, submitting 2 pages to the title company as opposed to the complete trust document, which again will lay out the distribution of the property. You can pretty much put anything you want in your trust, so sometimes family members will put some pretty personal information in there, and that's a great scenario for wanting to have the certification of trust. So I include that in all of my estate plans. Also, obviously, real property, we need a deed. That's the big one that sometimes surprisingly is overlooked. People will do the estate plan and forget to put their house into the trust. To avoid that, I put the house into the trust for them by creating a deed as part of my estate planning documents. And then that gets recorded with the county. Sometimes, people think, oh, well, now the property is in my trust. It's not in my name anymore. How complicated is that? It's not complicated at all. If you decide to sell the house, you simply sign the deed as a trustee as opposed to an individual. It's really a very simple process. So not a lot of, it doesn't create a bunch of red tape for you as an individual to create a trust and put your real property into the trust. 2 people you'll want to talk to if you have a loan on the property, a mortgage, you want to talk to your lender. Make sure that they're on board with the transfer. I've never had them say they're not, but they will want their records to properly reflect it. And your home insurance company, they're going to want to know that the property is now in a trust and can change the documents accordingly. The final piece of the full estate plan is going to be powers of attorney. So I'll do those for healthcare as well as finance. A healthcare power of attorney names an individual to make decisions for you in case you're incapacitated, but it also, the form that I use also acts as a living will. There's a section in there that lets you decide now how much effort you want medical professionals to take in the event that you're in some sort of catastrophic accident. When I'm counseling my clients, I kind of describe it as small, medium, and large. Small being do absolutely nothing, medium, do something if you think you can save me, and large being do everything possible to keep me alive for as long as possible. So that's nice to have in place ahead of time, because obviously if you have that accident, you're not going to be in a position to make a decision at that time. The other, the other power of attorney is for finance, and there are several different ways we can do this. Sometimes you'll have clients who are very young, and with those clients I will suggest a triggering event, meaning a power of attorney is going to be effective on the date it's signed, unless you put something in there that says it's not effective until something happens. So traditionally, for a financial power of attorney, it will be a court order deeming an individual to be incompetent, or it'll be a statement from a sworn statement from a physician saying this person is suffering from dementia, or something else has happened, they're no longer able to handle their affairs. That's what we call a triggering event. So that will prevent abuse of the power of attorney if somebody were to do that or want to do that, because you'll need some proof that you are no longer able to make decisions for yourself. Sometimes if it's an older family that I'm working with an individual who's getting much older, obviously they're still able to make decisions, or I wouldn't be having them sign these documents. But sometimes I won't put those triggering events in there because it can be a stumbling block if there's an emergency type situation. So it really depends on the family. We talk through the different options. Many times when my clients are older, they'll bring with them individuals that they're choosing to act on their behalf, so we can have those discussions up front. But in terms of real estate, just one thing I wanted to point out is that a lot of times when people are selling on behalf of a deceased loved one, first of all, they're not thinking clearly. They're mourning the death of a loved one, and they're dealing now with the idea of basically distributing all of their loved one's property. Many times people will tell me, well, I'm their power of attorney, I'm their power of attorney. And that may have been true in the last few years of that individual's life, but one important thing to note is that powers of attorney cease to exist at the death of the agent or of the principal. So no power of attorney is effective if the person has already passed away. And I just think that that's one thing to keep in mind. If you're an agent and they say, I'm the power of attorney, you're going to want to ask some more questions or suggest that they talk to a real estate attorney or the estate planning attorney to figure out exactly where they are and what capacity they're acting in. So in terms of these full estate plans, I kind of wanted to go through the process a little bit of how do I figure out, what's best for my clients. And that's a very simple process of talking about what they have and what we're going to do with it. So traditionally, things that people have, real property. That's the big one because for most people, that's their biggest asset, and it's going to be their biggest asset. So we'll look at, what kind of property do they have? Do they have a house? Do they have a vacation home? Do they have a vacation home that's shared with brothers and sisters? That kind of thing. And with real property, the only way really to get it out of your name and therefore out of your estate if you pass away is to deed it into a trust. So if somebody owns real property, my recommendation almost always is going to be, let's put a trust in place. Going back to the land trust, I did have a situation recently where a family came to me and their mother owned a house and it was in a land trust. The land trust had already named the children as the beneficiaries. So the idea here for that family is mom is going to live in her house. We're all going to take care of her. We're going to take care of the house. We're going to make sure she stays there until she passes away. And as soon as she passes away, us kids are going to own it equally. So in that situation, I've got a pass through. I don't have to be worried as an attorney about the estate owning that property. The property is already in a land trust. And just so you know, holding property in a land trust costs money. Holding property in a trust does not. So just one thing to keep in mind when you're making these decisions. That property is not going to pass to my client, the mother, because it's already going to her kids. So in that situation, I could bypass the analysis of do we need to put the real property into a trust. The land trust, because the kids are named as beneficiaries, is going to take care of that for her. If she were named as the beneficiary, we would have a different situation. Because if she passed away the next day, that property is going to land in her estate, and then they're going to go through probate. So some of the other things we looked at too, bank accounts. In her situation, she had her kids already on her bank accounts as they were going to be the owners. So again, I didn't have to worry about is the bank account going to end up in her estate. And they also kept the balance super low. So even if it were in her name, it wasn't worth more than $100,000. So that asset gets crossed off. We don't need to transfer that. We don't need to consider that. We also want to look at retirement accounts, stocks, personal property that might have a specific value, some kind of heirloom item, a painting, I had a fine rug once came up as an issue. I didn't know, but that's why we have these conversations to find out from clients what potentially might be out there that's going to tip the scales in terms of what the estate is going to be worth. Another big consideration is if there's a family business. So that's a whole other conversation. If you started your own company when you were young, you're an electrician, and it's doing great, and that's how you supported your family your whole life. If you pass away and you didn't do anything, all those business assets are going to be yours, and they're going to land in your estate, and you're going to pull your estate into probate, without wanting to have done that. So again, that's why it's important with attorneys to have these conversations with their clients to make sure that everybody's on board as to what all the assets are. And I've found over and over again that owning your own business is something people don't consider as their own asset. I don't know what the mindset is, but that is one that comes up repeatedly, and we're having a deeper conversation after that comes up. There are definitely ways to handle a family business. but it also depends greatly on what the family plans to do with the business. If the son is now also an electrician, or the daughter wants to, join in as well, and the family continue the business, that's a different conversation than if the business is going to be winding down and closing its doors. So yeah, I mean, that's basically, we look at all those different things and we make the determination one by one, okay, what's going to land in the estate and what can we transfer to the trust or to somebody else. So again, in that situation with the mother who had the property in the land trust, I didn't do a trust for them because she had so few assets, and the ones that were going to pull her into probate were going to be taken care of in some other way. So just because I say a full estate plan might be the easiest, it doesn't necessarily mean that every single person is going to need one. It's really just a conversation that I have to have with everybody on a one-on-one basis and make the determination from there. One final note about having the trust in place, and this is kind of a common misconception I think from people that I speak to, is the trust. We're using the trust to avoid probate, as I've said, this $100,000 level. We're not talking here though about avoiding estate tax. And estate tax is something the federal government and the state of Illinois imposes if you've got a lot of money. And by a lot of money, I mean the federal government, right now the level is at, I think it's $12.92 million. So if you have that much money and you haven't done correct estate planning or you just have so much money you're unable to reduce it, you're going to have to pay federal estate tax. And that comes from the estate. This is not on the inheritance itself. The individuals who inherit the money are not the ones who are paying it. It's the estate itself is going to have to pay these taxes. The number for Illinois is much lower. It's $4 million. So there are definitely some considerations there, and there are things people can do. That's where you get more into actual planning for your death is kind of how I look at it, because you're going to start to do things like give away your money, give money to charities, take out insurance policies, basically on behalf of your estate. The insurance policy is set up so that the proceeds of the life insurance policy will actually pay the tax itself, and then your remaining assets can be distributed to your heirs. So that's a much more complicated process. For me as an attorney, I have sort of made the decision that I think estate planning is really important, and I think a lot of people don't do it because they're afraid of the cost. So I have focused my practice on keeping my costs low. And what I'm saying by that is if I have a client who comes to me and is very wealthy, I usually refer that out just because, not that I want them to pay a higher fee, but they're going to need more servicing. And they can afford the fee, which is nice, but it is going to be more costly for someone to put the correct estate plan in place because it's going to be much more complex. I tend to keep my fees lower. I like to work with just the more average family who really needs this as a resource, needs to have this in place, but can't necessarily afford thousands and thousands of dollars to do so. And one more thing on the estate tax itself, not that, I know that it's really high for the federal government, but in 2025 there is a law that is expiring, and if it's not renewed, no one knows what's going to happen with that federal cap of the 12 million. It could go up, it could go down. No one really knows at this point. So 2025 is when that is set to expire. It's kind of a date that attorneys who are doing estate planning are keeping in the back of their head to just kind of forewarn people. We don't have a crystal ball. We can't. We could put something in place now, and in 2025 it might not work the way we think it's going to work right now. And that's really true for a lot of estate planning. We're working with the laws as they exist right now, and laws tend to change. So we're doing the best that we can with the situation we have in front of us. And for the most part, it's working out well. So, and hopefully lawmakers understand that and won't, completely turn the tables on everybody. But just in terms of steps to take when a loved one does pass away, the first thing you're going to want to do is you're going to need multiple copies of the death certificate. And then the second thing you're going to want to do is make sure that the will, if they have a will, gets filed. Again, according to the statute, it's 30 days after they pass away. And again, if there is no will, the probate case is you're going to want to have that opened within that same time frame so that things can be distributed and you can start taking care of things and not just letting them sit. With a trust, you're going to also want to make sure that there's a bank account and a tax ID number opened. Once somebody passes away, both the trust and the estate do have to start filing a tax return. How many tax returns might need to be filed is going to depend on the distribution. If there's a trust and it remains open, an example of this might be if there's a lawsuit that's filed once the individual passes away for malpractice or a lawsuit against a nursing home, that kind of thing. That trust is going to need to remain open. The estate is going to need to remain open until those lawsuits are resolved and the proceeds are received and distributed. So there will be tax returns that have to be filed, and you're going to want to have an accountant on hand to help out with that. And if you are the person who's named to be in charge, if you're the executor, if there's a will, if you're the successor trustee, or if you're named as the settlor in an intestate succession, you're going to want to have a very clear record of any distributions you make. If there's a provision in a will that says so-and-so can have this particular painting or this particular piece of jewelry, you're just going to want to make sure that you're recording everything that you do. With a trust and with an estate, you do have an obligation to potential beneficiaries or named beneficiaries to give them an accounting of the distribution. So that's a very important piece. And then just the little nitty-gritty stuff of the everyday. If there's a house involved, make sure somebody's still paying the utilities, make sure they stay on, make sure the insurance continues to get paid. These are little minor details that are sometimes missed. When I do an estate plan, I include a retainer letter, and the final page of that letter gives, a list of these different items. And I tell my clients, put this with your estate planning documents so whoever comes after them has the opportunity to take a look at it and say, oh, okay, this is what I need to be doing. So I realize that wasn't a full hour, but if you have any questions, more than happy to answer them.
Yes, I have two questions. The first one is, can the trustee be in a different country?
Yes, yeah. It's just the trustee just needs to, so traditionally with the trusts that I do, the trustee is going to be my client during their lifetime. So when they pass away, they're going to name a successor.
The successor can be?
And the successor can be in another country. You just want to make sure that they have copies of all the documents and that they're capable of traveling to the United States, that they understand the language, so it won't be too much of a barrier for them. There's also situations I come upon where somebody either doesn't have a family member or they have a family member that they've had a falling out with, and they don't want to name them as the person to take over for them, and they don't want to burden friends or neighbors, so they'll use a trust company. So there are companies out there that will act as your successor trustee. They do it on a fee, obviously. Some of the ones that I've seen are maybe like 1% of the value of the estate gets paid to the trust company, and then they administer everything. I have sometimes parents who want to put the estate plan in place now. Will do that if their kids are too young still to really take over for them, or they're concerned about their financial wherewithal to handle it for them. So that is an option as well.
Okay. My second question is, if a client makes a will for example, in Illinois, and they are including the home that they are living now, and they move to a different state, does that will follows to the next state, or they need to create a new one when they move?
Yeah, most states in the United States have reciprocity. So if you execute a will in Illinois in accordance with Illinois law and you die and you're living in another state, your will in Illinois is still valid. It can still be used to distribute your property regardless of where it is.
Follows like to the new address.
Yeah,
Okay.
yeah.
Okay. Thank you.
What if you have property in a different state? Will you have to do probate in 2 different states then?
Potentially, yes. So I have that conversation with my clients often. So you can do a couple of things. You can have your will done in the other state and handle it there. Or often what I will do is a trust here in Illinois, and then we contact the recorder's office in the other state, and we'll record a deed in that county transferring the property into the Illinois trust.
Gotcha.
What is the difference between this living trust and estate trust?
Nothing, it's a title. So basically, and this comes up a lot because I do a lot of real estate. I see all these different names for trusts, you know, somebody's irrevocable trust, living trust. They're actually confusing those terms. So the trust is going to be alive, so to speak, until it's fully administered and all the assets have been distributed. A trust is going to be revocable during the lifetime of the initial trustee. So when my clients come to me and say, hey, I need an estate plan, they're the trustee of the trust, and that trust is revocable during their lifetime. The moment they pass away, their trust is irrevocable. So I have people come to me and say, oh, well, can my successor trustee, you know, change these terms or, you know, exclude one of my kids if they don't like them? And the answer is no. Because as soon as you pass away, whatever distribution you've put in that trust is now irrevocable. So this happens a lot with banks. They get very confused if the trust is named the irrevocable trust and then the person is still alive and they want to make a change. It becomes very confusing. So I leave it out completely. I leave those titles out completely. It's just the person's name or their family trust, and that's the end of it, and there's a date. The date is important.
Did you say, okay, you put your properties in the trust, but you said about bank accounts, if they're over 100,000, regardless of whether you have beneficiaries at your bank, it has to go through probate?
Well, so if you have a bank account and you don't name beneficiaries, and you pass away, the bank account's going to belong to you. So that would go into your estate. So you want to talk to the bank. I've found that it's hard for me to tell people exactly what to do when it comes to a bank account because every bank is going to be different in how they want it handled. So you can name, what's most commonly done is, well, if you have a joint account, that's one thing. The other person is going to be the owner of it. But if you have an account and you're married, we'll usually name the spouse as the beneficiary and then the trust as the next beneficiary. Or if it's an older person, they'll put one of their kids on the account. And then that they're going to become the account owner. So what we want to look at is what is this bank's procedure for what's going to happen to this money when I pass away. And then we kind of take it from there and decide, okay, well, this bank wants it done this way, so we're going to do it that way. This bank wants it done this way, we're going to do it that way. The important thing is to look at each of the assets and figure that out, not just guess or assume. You know, retirement accounts are a big one. People are always like, oh, I named my kids, I know I did. And half the time they didn't, they just think that they did. So it's important to kind of go through and really look at what you've actually done. And doing an estate plan is a great time to do that because then you've not only got your documents, but you've just looked at everything and you can say, okay, now I know I'm good, I'm okay.
The term beneficiary does not necessarily mean it's pulled away from possible probate. Is kind of what I'm hearing, depending on how it's set up.
Oh.
As opposed to like a bank account. Joint account, easy. You got 2 owners.
Yes.
I lost one owner. The other one's still there. But if it's beneficiary, depending on what the account is, and without any, well, is it, yes, you get it, but it's part of the estate that you get, or does it pass to?
Well,
Is
in-
that the distinction we're
yeah,
watching
so
for?
That is the distinction that
And
we're
that's-
watching for. So
that's
with
why
an
we do.
IRA, yeah, with an IRA, I know I'm okay because those are
Right.
pass through. They will pass right through
Right.
your estate directly to whoever your beneficiary is. Bank accounts are a little trickier, so that's where we want to make sure we're talking with other people as well.
Kendra, I know one person, in case if he will heard a situation like that before, if he will want to sell a house, would he have to do probation? Or
So
it's gonna be
probate,
too
yes.
late?
He's gonna have to do probate, because what's gonna happen is, let's say he tries to sell the house, there's gonna, even if there's no attorney involved, there's gonna be a title company most likely.
Uh-huh.
And even if they just, transfer it to each other, eventually there's gonna be, when they try to sell it, there's gonna be a title company involved. So the title company is gonna look at this and say, well, what happened to, I don't know his name, but the dad, they're gonna wanna know what happened to him and how any transfer to somebody else can legally be done. And the only way it can legally be done is if there's an estate, if there's a representative of the state appointed and put in charge, and that's gonna be done through probate.
I see, thank you.
That's the exact situation that my clients ran into that I was talking about at the very beginning. They just assumed that because it was a relative's house that somebody could just sell it to them, but it's just not the case.
The limits on probate, that's like per asset. I have a $50,000 house, $25,000 checking account, but I'm keeping under it all, even though the total may be more than 100, but each one of the other, again, loosely determined asset is under, we're okay. It's not a total net worth of 100,000.
No, it is your total net worth.
Oh, total net
Yeah,
worth.
it's not per asset, it's
Okay.
everything altogether.
Because I was gonna lead to my next one about the estate taxes, is depending on the state, some of them are relatively small.
Yeah,
2% or 2 million.
right,
And-
right.
Even some of us get kind of close to that when you put it all, you
put
total
it all
worth
together.
when you pass.
Yeah,
The,
yeah.
the guy worked for 40 years, there's a reason why,
Right,
So
right.
yeah,
Yeah, so you
Excellent.
gotta start getting rid of stuff.
yeah. Well, no, he had it all, he did what you do. He had it done for me, so it's gone, but yes. And then when, at the time of death, okay, now the house is dad's, he's gone, it's all in his name. Whatever else we've got set up, not worried about that. But the utilities, the insurance and stuff, that can just stay in place until the state's out. I mean, there's not like, somehow the insurance company has to have a new owner or whatever, the state as the new owner.
Oh,
You just let them
no.
know that we're making
Yeah.
the payments, we're getting this going.
Yes, yeah, the most important thing is that the payments are
That's what-
made
yeah, you keep
to
up with
maintain
everything, but-
insurance, yeah, yeah.
Okay. Cool.
What about the property? You said if mortgage on the house, right? So what is the steps to get this house on the living trust?
So when I do a trust for my clients, I include a deed. So when they come in and they do the final signing and sign everything, they're also signing a deed. I then take the deed and I do it through a recording service because it's just more efficient for me than driving around to recording offices. So the deed will get recorded that the property is now in a trust. Before we get to that point, I have my clients talk to their lender because technically there might be a provision in a mortgage that says if you transfer this property to another entity and don't tell us, we can call the note due. So you want to avoid anything like that. I mean, no mortgage company is going to go through that process if you're paying your mortgage. That's not going to be an issue, but you don't want to let it pass either. So you just tell them, call them up, say I transferred my property into my trust. When I did it, my lender was just like, okay, and they just changed the name on my statement. So it kind of depends on your lender. If you're going to refinance and you're thinking about doing an estate plan, you can save yourself a couple of fees by just doing the refinance into the trust. It's a good time to do your estate plan.
And if it is business included in living trust, then like how tax paid through living trust or? is it-
No, through your business, the business would still be a separate entity. What we want to avoid is, so again, these trusts are not intended to be income producing trusts during your lifetime. So you want to keep your business as the income producing entity, and just continue business as usual. But what we would do with the trust is look at, you know, who's going to be the beneficiary of the assets of the business, and you want to make some changes there so that if you passed away and the business was suddenly there without you, how would the assets pass? And there are things you can do with stock certificates and naming the trust as the beneficiary of the stock, so that, and putting provisions in the trust that would allow the trust, or essentially the successor trustee, to make the decisions necessary to wind down the business and take care of the final things that need to be done for the business.
Besides your personal asset, let's say the home you live in, but you have rental properties under an LLC now, does the whole LLC have to go under the trust, or does that handled separately? Because you have several properties, you know, that gets more
Right.
involved.
Yes, it gets a lot more involved. So with the LLC, there's a couple different options. You can look at options of creating, like I said, some kind of stock certificates that would go to the trust at the time of your death, or you can have some kind of business succession plan in place that there's somebody else that's going to take over the business after your death, and then the business would still be alive, so the assets would still be over there, and the person that takes over would then be responsible for either continuing the business, or, you know, what you don't want to do is do nothing and have nothing there in place.
And what is your fee?
I don't know if I'm allowed to discuss that. Yeah, it's being recorded.